Okay, so recording has started, and I can see we've got quite a few participants joined. So I suppose we'll kick off. It's a bit tricky without seeing everyone else, but hello everyone that is out there watching, participating. My name is Steph, and I'm a solicitor in the CLE Community Legal Education team at Legal Aid. I'd like to first start by acknowledging the ground and the land that I'm coming to you from today. I'm in Newcastle, the Hunter region, and traditional custodians of my land, the Awabakal and Worimi people. I am very grateful to be living on this land, this beautiful place, Newcastle, and feel grateful for the Aboriginal people for caring for it for 70,000 years before I've walked on it today. And wherever you're coming from, I'd like to acknowledge those lands in which you're all coming from. It always was and always will be Aboriginal land. Now I would like to present the other heads floating around in the screen with me today, Rochelle and Alex. We are all solicitors here at Legal Aid. Alex is our resident employment solicitor. He's going to take you through our employment words today. Thank you for joining us, Alex.
Pleasure.
And Rochelle is our social security NDIS specialist. Both of them have expertise and experience beyond lots of people in their areas, and we're very grateful for them sharing with us today. So a couple of housekeeping things before we get started. I don't think any participants are able to join, but if you could just leave your videos off because it is being recorded and on mute. There should be a question or a chat section at the bottom of the page. If you have questions along the way, please feel free to type them into there. We will have some time at the end of each section to answer the questions, but if they are specific questions to your situation or questions that require some more advice on, we won't be answering them today, just questions that relate to the words that we're going to be talking about. Speaking of what we'll be talking about, as I mentioned, employment law will be covered by Alex, and we'll be going through general employment law words that you might hear, unfair dismissal, general protections, wages, entitlements, discrimination, bullying. Then we'll go through some social security and NDIS law related words, and Rochelle is going to take us through them. This is hopefully going to leave you with more knowledge on what legal nuance words mean, how to better explain them to your client. So today we're trying to help you help us in a way, in a roundabout way. There's lots of words that you might already know, and there might be words again that you don't already know. We're going to start off with a quick question, and I hope this works for you all. I'm launching it now. If you could all answer the question, which is, have you listened to Legal Aid podcast? We have a podcast. It's called Law for Community Workers. There's a subtle plug if you didn't notice that. It's a great podcast. It talks about lots of legal issues, talk to lots of specialists, and it's targeted at people that work with similar clients, people that might share clients with us. A few people look like they have. 7. Quite a few no. This is your chance. Couple of answers trickling in. Okay, I'm going to end that now and share the results with you all. So 33% have and 67% have not. Next time I run a webinar, everyone's going to say they have. It's going to be that. All right, so I'm going to hand over now. Oh, I've just got a bit of an overview here, sorry. So today we'll be talking about lots of legal words, but I thought it would be a good idea to visually show you the court system, tribunal system within Australia. So at the top we have the High Court. It is not an area that Legal Aid often goes to, or many people often go to, but the state tribunals and federal tribunals, which are on the side, are more commonly used by both these areas of law. They do trickle into the court systems, which you can see go upwards towards the High Court. So that's just a visual representation of the court system in Australia. As a refresher, we put this in all of our legal words webinars. Now, handing over to Alex, the employment man. who will run you through lots of words for employment law. Thanks, Alex.
No problems. I think the PowerPoint just needs to flick up onto the live version, so we can see the employment law page.
Can you see it now?
We can just see the presenter's slide, not the whole thing, not the. So if you go from current slide and you open it up,
I can see 2 PowerPoints here. So sorry, everyone.
Perfect.
So
that's a
now?
poll question.
Beautiful.
Yeah.
Okay.
Perfect. So, as Steph was saying, I'm an employment law solicitor with Legal Aid. So a little bit of a background what Legal Aid does with employment law. We provide advice, minor assistance, and in some circumstances undertake some casework in a range of areas of employment law. Mostly, I've summarised it there: unfair dismissal, general protections, wages and entitlements claims, discrimination in the workplace, bullying, and sort of general contract matters. We have advice clinics in a whole range of locations, and we also make submissions to relevant employment law issues to try and advocate for change where it's required with the law. And I also believe we have a poll question as well to start off with. So I think Steph can set it going.
That launch.
So it's just wanting to get it if you've had any experience with the Fair Work Commission, the Fair Work Ombudsman, the Federal Circuit Court or the Federal Court, which are basically the jurisdictions where most of the employment law issues will arise. So you can choose more than one, I believe.
Yes, you can choose more than one, and we've got a few people answering.
So
a lot of people have been to Federal Circuit Court, it looks like.
Okay.
Less to Federal Court. A few trickling in still. 5 more seconds. Okay, it looks like answers have stopped coming in. I'm going to end that poll and share it with you all now.
So, yeah, that's probably, I think, a fair statistic. I mean, a lot of you would have had experience with unfair dismissal terms and general protections terms and wages terms. So that's good to know. So some of these terms, as Steph said before, are quite general and you might already know, and others might be a little bit more specific. So let's make our way through. So I'll just start off with some general basic employment terms, and then we'll shift into specific areas. So first off, probably one of the major terms in employment would be an employee. So an employee is a person who works under a contract of employment for an employer. Now, this doesn't have to be in writing. It can be a verbal agreement. So it's just someone that has agreed to do something for an employer, some form of work. Employer is an individual, or it can be an organization, and they hire people to work for them in exchange for money. So the people who are paid to do the work are the employees, and the people that hire them are the employers. Then it starts to shift a little bit, and you have specific types of employers, and then things a type of employer, it's called an independent contractor. Now, an independent contractor is not an employee, it's not an employer, it's someone that works for themselves and they have a contract for service. So they are their own boss, they manage their own business. So they have different rights, there's different protections. They have less protections than an employee, to be honest. A casual employee is a type of employee, and often when we're doing advice, we're giving advice to people, and then they'll have to interpret what a casual employee is as opposed to a permanent employee. So a casual employee is someone who works on an as-need basis when they're required. There's no guarantee that they'll get work. Under the Fair Work Act, just recently, this is probably a good one to go through because this has changed recently. A person is a casual employee if they accept a job offer that doesn't include a firm advance commitment. So you're going to have this much work for 38 hours a week for ongoing. It's just people that are engaged for small periods of time. There's no guarantee that that work will continue. A permanent employee is a person that's in an ongoing job, something that will continue. There's no set end date. They usually would get paid. If it's a full-time employee, it's 38 hours a week, but other permanent employees can be 20 hours a week, as long as it's set that every week they're guaranteed those hours. A temporary employee is someone that's employed under an agreement with a fixed end date. So that's different to a contractor, who is someone that has their own business. A temporary employee is someone, you're employed as a permanent employee up till 30th of June. That's fixed. It's not ongoing, but they're not casual. So there's a few different types there. Now, I perhaps should have started with this, but this is the starting point. In Australia, the main law that governs the employment relationship is known as the Fair Work Act. The Fair Work Act. That is the law that governs majority of employment relationships in Australia. The Fair Work Commission is a workplace relations tribunal that operates independently to anyone, that has the power to carry out a range of responsibilities and functions. These include, that's where someone goes where they've been unfairly dismissed, they have a general protections claim. These terms, if you don't know them, I'll go through shortly. Enforcing some employment conditions, they create the rules around which the minimum rates exist for payments for different industries. So that's the Fair Work Commission. Now, it has to be distinguished from the Fair Work Ombudsman. So the Fair Work Ombudsman is Australia's also independent statutory agency, which serves as a central point for people to get information for free, not advice, just information on Australia's workplace system. For example, you might get a client that needs advice about what rate of pay they should get. The Fair Work Ombudsman is a place that you'd go and explain what job that you do, what should I be paid for doing that job. That's sort of the best, that's sort of what they're most commonly used for. Whereas the Fair Work Commission, the one we talked before, that would be where someone, if they were terminated from their job and it was unfair, that's where they would go. So, I mean, it would have been helpful if they called them something slightly different, so people can get those mixed up sometimes, but they're the two main tribunals. Court. Well, ombudsman is not. So the next one is national employment standards. So these are the minimum entitlements that apply to all employees, and they are covered in the Fair Work Act. So when someone says national employment standards, which we're going to go through shortly, and I'll go through the different types of things, but just to give an example of what one is, it's sick leave. Entitlement to be paid sick leave. That is an employment standard, and everyone has that who's an employee is entitled to these kind of benefits. A hearing. You may have heard of it in the context of other areas of law, but I just in the context of employment law. So it's a process which, by, for example, someone in the Fair Work Commission or a judge in a court will address and resolve a dispute, in the case of employment, workplace dispute, by making a finding as to whether or not the applicant's claim should succeed or be dismissed, finished. After the parties to the dispute have made their arguments and provided their evidence. That's what a hearing is. A conciliation is a process which a lot of claims, again, which we'll speak about unfair dismissal in the future, general protections. Conciliation is a process of negotiation that can occur during these claims where parties to the dispute try and reach an agreement before going to a hearing. A neutral person, a third party that has no, they're not on anyone's side, called a conciliator, they'll take an active role in trying to help parties reach a settlement agreement. So reach an agreement without needing to go to the next stage to have a decision made. That's called conciliation. So that's the first page. And then now we move on to the next list. Arbitration, that's a type of hearing. So we mentioned hearing before. An arbitration is just a type of hearing. And specifically in the employment context, in the Fair Work Commission, where evidence from both parties Usually an employee and an employer is provided, and the commission member will make a decision on the dispute. That happens in an arbitration. It's just a type of hearing. Settlement, you heard me mention settlement in conciliation. So it's when parties reach an agreement to resolve a dispute. It's just an agreement to settle a problem. Now, most of what we're talking about, without getting too technical and legal, is about the Fair Work Act, which is a Commonwealth system based on people employed under the Commonwealth system. Some people, like myself and my colleagues, we're state system employees. So different rules apply to us. So if someone says state system employee, that could be a New South Wales public servant or a New South Wales local government employee. And so they're covered, we're covered, or they are covered under New South Wales laws and not the Fair Work Act. I won't go into detail of that. It's a small amount of people. Majority of people are covered under the Fair, by far the majority of people working in Australia are covered under the Fair Work Act. The Industrial Relations Commission is the body where someone that is employed in the state system, like as I used the example, us, where they would go in the case they were terminated or had issues in relation to their employment. So majority of people don't go to the Industrial Relations Commission. Now, I've got labour hire workers here, and a labour hire worker is an employee, but they're a person that is employed by one company, a labour hire company, to work elsewhere, the host company. And this comes up quite regularly. So I think this is an important one to note, just from my personal experience, that often employees that require interpreter are employed through this labour hire arrangement. And it's important to know because different legal responsibilities can apply in this. So a labour hire arrangement is when an employee is employed by a labour hire company, but they do their work elsewhere. A sham contract. It's when a business or an employer tells a worker that they are a contractor, which we spoke about before, when they are actually an employee, which we also spoke about before. That kind of conduct is illegal, and often it's done by employers to avoid paying entitlements. As I said, contractors have less rights than employees, so often an employer will say to someone, you're a contractor, to avoid having to give them the rights of an employee. That's a sham contract. Casual conversion. So this might be something that comes up more often now as well, given the changes, but it is one of those national employment standards I mentioned that everyone that is entitled to gets. For a casual employee who has been casual for a certain period of time, you know, I'm not going to go into the detail of that, but it allows them to become a permanent employee, whether that's part-time or full-time. A prospective employee, if someone says that, that's an employee who's likely to be employed or considered, being considered for employment or negotiating possible employment. So they're not an employee yet, but it is a consideration. Workers' compensation. It's not exactly an area that we advise in. Well, we don't advise on workers' compensation, but we do have to use the term regularly. And workers' compensation is just a scheme of insurance that provides compensation, financial compensation, for employees who suffer an injury at work. A union is an organisation or body that acts as an intermediary, a third party. They represent its members and with negotiations with the employer. Unions give workers the power to negotiate for better working conditions and other favourable benefits through the bargaining of the group. And the union's role is to do that for their group. There's many, many, many unions out there. Evidence. So, I mean, this is a broad concept as well. Some of these concepts apply obviously across all legal, different areas of law. But I've tried to narrow it down, in my opinion, as to how you prove the facts of your case. So it can be documents, it can be your statement of, the employee's statement about what happened, or the statement of a witness. That's an example of evidence, but evidence is how someone would prove the facts of their case. A pay slip. A pay slip's a document given by an employer to an employee. It can be in paper form or it can be sent through an email, and it shows how much they've been paid during that period of work. It should show tax, It should show the overall pay. It should show all the other relevant deductions. The law requires certain rules as to what's included, but as a general summary, it's just a pay slip shows what an employee is paid for that period. Notice. So often employment lawyers use the term notice. Notice period is the length of time that an employer or an employee must give to end an employee's employment. So it works both ways. If a permanent employee, if you're leaving your employment, you have to let them know, you have to give them notice. If an employer is terminating your employment or ending your employment for whatever reason, they have to give you notice, a period of time, whether it's paid or worked. That's the notice period. So that's some general ones. Some of those general ones also apply across these areas as well, but I focused on probably the most important ones in the relevant section. So unfair dismissal. So dismissal is when an employer ends the employment of the employee, finishes the employment. It can include things like your role is redundant, which I will explain shortly. It includes the term firing an employee without warning, or firing them because they're not performing. So there's a range of reasons for dismissal, and it's not necessarily a negative thing. It's just the ending of the employment. Termination is just another word for dismissal. So people use the word dismissal, termination, firing, sacking. You'll hear all these words. They all mean the same thing, which the legal term that would get used is dismissal or termination. So unfair dismissal is when an employee is terminated and it's unfair. It's harsh, unjust, or unreasonable is the legal term. That's as far as you could go with that. The redundancy is when an employer decides a specific job genuinely no longer needs to be done. So that could be because the business is closed down, or because they've changed the structure of the business and that job doesn't exist anymore. That's what a redundancy is. When that specific job, that role is no longer there. So that is a type of dismissal. Time limit is an important concept in employment law. In an unfair dismissal, it's the period of time that you have to start your case in the Fair Work Commission or in court if it's a wages claim. Otherwise, if you don't meet that time limit, the employee would risk losing their chance to argue their case. For example, in unfair dismissal, there's a 21-day time limit to apply for unfair dismissal at the Fair Work Commission from when you're terminated, just by way of example. Another term that comes up in unfair dismissal often is minimum employment period. So not everyone can do unfair dismissal. So the minimum employment period, when it's said, that refers to the minimum period of work that you have to have done to be able to apply. In the case of unfair dismissal, it's 6 months. 6 months of work when it's not a small business. It's 12 months when it's a small business. Now, what's a small business? A small business employs 14 or less employees. And so sometimes that's hard to figure out, and sometimes companies have multiple companies, but the general principle is that 14 or less. But if they have other companies, they could be included, but that's a matter for when you're advised. I thought it was best to say small business. Then misconduct. So when someone's accused of misconduct, it's when an employee or an employer behaves in a way that's unacceptable in the workplace. For example, yelling at a coworker or being drunk at work. That would be an example of misconduct. Performance often comes up with unfair dismissal. If someone's not performing or they're saying they're not performing, that might be a reason why they lose their job. That's when the term will come up. So what do they mean by performance? Performance is an employee's ability to complete the tasks and duties of their role to a good standard, an acceptable standard for the job. So that's unfair dismissal. Now, the next one and the next slide would be about general protections. It is a complex area, so sometimes the terms can be difficult to interpret. So I've tried to break them down as simple as possible. And sometimes when the lawyer will give advice about the concepts, in context, it is also perhaps easier for you to understand and translate. So general protections are a set of rights for employees that stop employers from taking adverse action, which I'll define shortly, against them because of their use of a workplace right, because they were absent from work, because they were sick or injured, or due to some sort of unlawful discrimination. So what is adverse action? Adverse action is action taken by an employer that's unlawful because an employee has or tried to use a workplace right, which I'll define what workplace right is shortly, and then we can put them all together. So adverse action could be something as simple as terminating, dismissing someone's employment. That's clear adverse action, but it could also be things like cutting hours, demoting someone, or treating one employee differently to another employee. Now, a workplace right is a benefit or an entitlement given to an employee based on the law or based on their award, which I'll talk about shortly, enterprise agreement, that kind of thing, including a right to make an inquiry. So the best way, I think, to explain these terms other than those definitions, to give you an example. So I have a workplace right to make a complaint about my pay. I've made that complaint about my pay, and my employer adversely acted against me because they terminated me. So that's the general protections claim. I exercised the workplace right. I was terminated. I have a general protections claim. Industrial activities. So we talked about the union before. Industrial activities is action taken by an employer or employees to settle a workday dispute about working conditions. And the most common example that people probably would be aware of industrial action is a strike. That's a form of industrial action, activities, I should say. Now, wages and entitlements. A lot of what we've spoken about, some of it will come in. So there's a lot of terms, again, that might be repeated throughout. So the national minimum wage is the minimum hourly or weekly amount that employers must pay employees in Australia for their work. It's a safety net. It's the bottom. Employees can be paid more. Different industries have different minimum wages, but the national minimum wage is the absolute lowest. And that's set by the Fair Work Commission, who we spoke about earlier. Now, an award is a legal document that outlines the minimum pay rates and conditions of employment for a range of industries. So you could be in the building industry or the cleaning industry or the hospitality industry or the fast food industry. All those areas, they have different awards that have different levels of pay for different levels of work. And that's all the minimum. It's possible for someone to be paid more, but they can't be paid less. Think of it as a safety net. An award is the minimum entitlements for that particular industry. Not every industry has an award. A lot do. There's over 140. There's lots of awards. Now, an enterprise agreement is one step further. It's a written agreement made between an employer and a group of employees, which sets out the terms and conditions of that business. Now, an enterprise agreement has to be registered with the Fair Work Commission. So think of it as, it's not an award, but think of it as a company making their own award that applies to them. And usually there's an award that applies to their business. And so that enterprise agreement couldn't be worse than that award, but sometimes there's things that it's beneficial that it's tweaked for that business. So bigger companies often have them, like Qantas, these kind of big organizations, they often have. McDonald's used to, they enterprise agreements. So yeah, that's what an enterprise agreement is. Now, I'm going through a few things here which are included in the NES, so they might come up, and they're different types of leave. So family and domestic violence leave has been a new entitlement, which is great, that's been introduced for people who are suffering family domestic violence to take time off up to 5 days of work each year. This change is about the federal government has introduced legislation for paid domestic violence leave in all modern awards. So it covered everyone. It will cover everyone. So, that's a great change that's come through. So annual leave, often people call it holiday pay or recreation leave, but that's annual leave. It's the same thing. It's for full-time or permanent employees, I should say, and it accrues at 4 weeks per year. So you get 4 weeks holidays per year. Leave loading. Leave loading is amount paid on top of your wages when you take annual leave. Employees covered by an awards or enterprise agreement may be entitled to leave loading. Not everyone's entitled to leave loading. It's an extra amount on top of your annual leave. And it would, depending on the award or the enterprise agreement that we spoke on before, whether or not you'd get that. Now, personal leave, this is commonly known as sick leave or carer's leave or stress leave. People call it a whole lot of things, but the legal term is personal leave. So personal leave allows people to take time off to help them deal with an illness for themselves, or if they have an illness of a family member or emergency or family responsibilities. A casual employee does not get paid personal leave. Compassionate leave. So that allows employees to take time off to deal with an immediate family member's death, including, and this can include things like miscarriages and stillborn pregnancies as well, or life-threatening illnesses and injuries. Community service leave, excuse me, allows for all employees, including casual employees, to take time off work for activities such as voluntary emergency management activities or jury duty. With the exception of jury duty, community service leave is unpaid. So jury duty is probably a one that might come up often with clients. A flexible work request is when an employee who has worked for the same employer for at least 12 months can request changes to their working hours, start earlier, finish later if they have to pick up their kids or they've got to care for a relative, those kind of things. Or they can only make the request due to their age or disability or care responsibilities. So overtime rates. Overtime rates are extra pay that an employer must pay some employees for any hours work that exceed their normal working hours, that go above their normal working hours under an award, enterprise agreement, or contract of employment. Penalty rates are higher rates of pay that might apply when someone works really late at night or really early in the morning or on the weekend or on a public holiday. They're penalty rates. Casual loading is the amount that is paid to a casual employee that's higher than a permanent employee, and that accounts for them not getting things like sick leave, paid, and annual leave. It's called casual loading on top of their fixed hourly wage. An allowance is an additional payment that an employee is entitled to do for certain tasks, maybe because they have to work at a certain location or have a special skill. For example, a common one that I often see is, if you have to work in a freezer cold room, there's an allowance for working in a freezer for the cold environment. It's often a little bit extra on the pay. And these kind of things are all covered under the award. They're all in the relevant award. That's why it's an important document. Unlawful wage deduction. So when money is taken from an employer's wage by their employer unlawfully, that's an unlawful wage deduction, when they take money out without permission. Unpaid wages. When an employer does not pay an employee their proper wages or allowance or entitlements outlined under the award or an enterprise agreement or contract. Long service leave. So long service leave, most employees in New South Wales are entitled to take 2 months paid leave after 10 years of work. If an employer has more than 5 years, but less than 10 years, they're entitled to get paid leave if the employer dismisses them for any other reason than serious misconduct, or if someone has to resign for illness. I mean, that's slightly getting to advice a little bit, but it's just another form of entitlement that someone gets after they've worked a significant period of time. And finally, piecework rates. So again, perhaps a term that often comes up for me when I'm having interpreters in advice is the concept of piecework rates. So often when people work on farms or industries like that, where they have to pick fruit or the like, it's when someone gets paid by the amount that they pick, pack, accrued or made instead of getting paid an hourly rate. Most people are paid an hourly rate. Some people are paid piecework rates, and that's all covered under an award. So when they say piecework, that's what they're referring to, often in that industry. Okay, discrimination and bullying. So workplace bullying is defined as repeated and unreasonable behavior against a person in the workplace, which creates a risk to health and safety. So that can be things like, it can come from anyone in the workplace, from a supervisor or a colleague, and that would be things like yelling, harassing behavior, intimidation, but then also things like impossible deadlines or workloads, being allocated inappropriate or unfair tasks, these kind of things. Reasonable management action. Now that's in the concept of bullying. That is things like performance or disciplinary action that can be taken by an employer. When that's reasonable and done reasonably, that's not bullying. So that's where that term comes up. Often, I'll give you the context of these terms. A client might come and say, I'm being bullied, they're putting me on a performance management plan. We'll say, well, if they've talked you through it and explained it to you, that's not likely to be bullying because it's a reasonable thing for an employer to manage performance reasonably. So that's reasonable management action. Sexual harassment. So sexual harassment is unwelcome conduct of a sexual nature which might make a person feel offended, humiliated, or intimidated. So this could include unwanted sexual advances or requests, sexualized joke, distributing pornography, touching a person inappropriately in the workplace. So there's a range of behaviors that would fall into that conduct. It's unlawful in different areas of public life, employment, but also in service delivery, accommodation, and education. So there's a range of areas where sexual harassment in that context, that's how it's defined. Now, unlawful discrimination is when a person is disadvantaged or treated less favorably based on a specific ground, such as their age, it's a personal characteristic, such as their age, their race, their sex, their disability, their sexuality, or their care responsibilities. That's unlawful discrimination when it's based on one of those factors. It can be direct. So direct discrimination happens when a person or a group of people is treated less favorably than another person or group. That's just direct. And indirect discrimination can occur when a workplace has an unreasonable rule or a policy that applies for everyone, but has an unfair effect on people who share a particular attribute, whether it's gender or race or sexuality, that policy unfairly discriminates against them because of that attribute. That's indirect, whereas direct is specifically to them. So, I mean, we could continue on. There's lots of terms, but I've tried to cover off the key areas that we've dealt with interpreters and the key concepts that I've found that are important to explain. So I'm happy to obviously ask any questions that people have about terms. I can't give any specific advice, obviously, in this.
Thanks, Alex. I feel like I learned something there. I think the sick leave is actually called personal leave. I didn't know that. So I'm getting some questions through. One, could you please explain the difference between a hearing and an arbitration? That was one of the first earlier words you described. The difference between those, a hearing and an arbitration. Oh, and we can't quite hear you, Alex. I'm not sure.
Sorry, I bumped the mute button. It was bound to happen. So I'll give the definitions of both and I'll explain again. So arbitration is just a type of hearing, but a hearing is the process by which a member at the Fair Work Commission, we call them members or commissioners, or a court, you'd call a judge most commonly, the process that they'll take to address and resolve a dispute by making a finding whether or not someone's claim should succeed or be dismissed after people have put their arguments, put their evidence forward. That's a hearing. An arbitration is effectively just a type of hearing. In the employment law context, it's a type of hearing that the term arbitration, we use it in unfair dismissal. So someone would have the conciliation, which I spoke about, that discussion to try and settle it. If it didn't settle, then it goes to arbitration within the Fair Work Commission, where it's a process where evidence is put forward before the commissioner. So it's effectively, arbitration is just a type of hearing in that context, but the term arbitration is the one that's used in unfair dismissal in our case. So it's used other places, definitely, but in the context of this presentation, that's how we use it.
Great. I hope that helps that person. If anyone else has any other questions, you can type them in the chat. I'm sorry it was disabled.
No
Thanks.
problem.
They said thanks, Alex.
No problems.
That's been helpful. I had the chat disabled earlier, so I'm sorry if anyone was hoping to ask a question earlier. You can send them through now and we'll get to them if you'd like. Also, I emailed around to all participants yesterday a list of the words with some space to put notes in. I hope that document's useful. If anyone has joined since I emailed that document around, you can put your email address in the chat and I'll send it out to you.
It's also good to note the Fair Work Ombudsman and the Fair Work Commission, just if anyone's interested in looking at their websites for the different areas that I've spoken about, they have documents with definition pages that cover all these things off. So if there's anything, I mean, I've tried to simplify it as much as possible, and their definitions might be a little bit more technical, but it's also another resource.
There's some really great resources on those websites.
Yeah, definitely.
Okay, well, if there's no more employment questions, we might pass over and start the Social Security and NDIS section to Rochelle. So if anyone wants to take us a moment there to refresh their brain, I've popped a little ice fire. I have no idea the answers, so if you can do it really quickly and tell me, put it in the chat. Oh, getting some email addresses coming through. So I'll be able to email those documents out. Informative. You're getting lots of good feedback, Alex. Okay, we'll jump into the Social Security section now. Okay, over to you, Rochelle.
Okay, thanks so much. So thanks so much, Alex, as well. Really useful to go through all of that content. So my name's Rochelle and I'm one of the solicitors in the Social Security and National Disability Insurance Scheme team. So our team at Legal Aid can advise clients about Social Security or NDIS problems at all stages that a problem may come up. So it might be an initial issue in terms of trying to claim a payment from Centrelink, or it might be an appeal that somebody has got at the Administrative Appeals Tribunal, or in relation to the National Disability Insurance Scheme. It might be in relation to seeking a review of a decision not to grant somebody access, or a review of an NDIS plan. So generally we give advice about eligibility for specific payments, advice about debts and how to challenge them. We could talk to people about their rate of payment and if there's any issues in terms of how much they're getting for their job seeker or disability support pension. We often give people advice about their relationship status under Social Security law and how that might impact their Social Security payment when somebody starts or finishes a relationship. As I flagged, appeals before the Administrative Appeals Tribunal, and getting access to the NDIS or responding to issues in an NDIS plan. The main things we do. Generally, we provide advice. We can also provide representation in both NDIS and Social Security matters if they are matters that are before the General Division of the Administrative Appeals Tribunal. So a poll, oh, so you're just on mute, Stephanie, but a poll question, if you could prop it up, I'm happy to read it out. Okay, so it's just useful for me to know what everyone's experience is in different forums to know where to weight the content. So if you could just let us know if you've had experience in the, what you've had most experience in, if it's single choice, it's Administrative Appeals Tribunal, in Centrelink appeals or review processes, or in any kind of NDIS appeals or review processes. So I'll just give you a bit of time to select the most relevant one of those, and just see where everyone's had some involvement before.
There's a fair few coming in, lots of experience all around, it looks like, mostly in AAT. Give you 5 more seconds. And ending that, and I'll share the results with you now.
Okay, interesting. Okay, we do do a bulk of our advice rosters and representation is at the Administrative Appeals Tribunal, and a lot of our client base require the assistance of an interpreter. So not surprising to see the Administrative Appeals Tribunal really high up there in that result. Okay, all right. So moving on just to our words. So generally, Social Security is basically what's known as the system of social welfare payments that are administered by the Australian government to eligible Australian citizens, permanent residents, or to some particular international visitors. Centrelink is the organisation that administers Social Security payments that someone would have face-to-face contact with. And Workforce Australia is a fairly new entity, so only in the last few months. People who have mutual obligation requirements, which I'll talk about a bit later in relation to getting a payment, have exposure to Workforce Australia, which is an employment service delivered by the Department of Employment and Workforce Relations. And they deliver services online or in person to people trying to find a job, looking for work, assisting with training and courses. The main words that come up when somebody has a Centrelink problem or an issue with a Social Security payment, or are trying to just get some advice in this space, are going to be largely about eligibility. Claim form is basically what somebody needs to put into Centrelink in order to obtain a Social Security payment. There's a requirement that a claim be put in and made to the department so that somebody's eligibility for the payment can be assessed. With the claim form, somebody has to put in identification. For Centrelink purposes, that generally requires that somebody proves their identity in passport, license, different types of third-party documents to show the person's address, their date of birth, and their particular details. There are particular exceptions to that rule at Centrelink and different alternative ways to prove somebody's ID, but it's generally about trying to show who the person is, where they live, so that Centrelink can make an assessment of what kind of payment the person might be eligible for. Residency is a huge issue for Social Security and for NDIS. It means whether the person is residentially qualified to obtain a benefit or a payment, or to get access to the National Disability Insurance Scheme. Residency comes up a lot in terms of whether the person has a citizenship, or if the person is a permanent resident, and also whether they have a newly arrived residency waiting period that they have to go through first before they'll be eligible for a payment. Assets. So Centrelink, when they assess whether somebody can get a payment, will look at the person's assets, and they'll look at the person's income. So a person will have to declare to Centrelink all of their assets and income, as well as the assets and income of any partner that they have. There's an asset test and an income test that are applied, and then whatever results in the lower payment is what test will be applied in the person's particular circumstances. So assets are those things that the person owns, for example, money in a bank account, cars, household effects, jewelry, boats, any kind of property in that sense. Income, however, is money that the person derives or receives. It can be from employment-related income. It can be from investments and sort of financial investments, and it can also be from large transfers of money from friends if they don't fit certain other definitions, like a one-off gift. Rate of payment is what the person will get in their bank account each fortnight for their social security payment. So somebody might be, for example, on the disability support pension, and they might have a query that comes up about their rate of payment. So they might have been getting a full rate of payment, the maximum rate of payment that can be given to somebody, and then all of a sudden their rate of payment has dropped by $100 per fortnight. So it just describes, based on the asset test and the income test, what the person's fortnightly rate of their payment is. Member of a couple is, this is a really tricky area for us. So member of a couple in, sort of layman's terms, or our understanding or a personal understanding of whether you're in a couple with someone is so subjective. Under the Social Security Act, there's a particular assessment as to whether somebody will be defined for Centrelink purposes as a member of a couple. And it goes to various factors across the relationship. So the social aspect of the relationship, the domestic relationship, the financial relationship, the level of intimacy, and also the commitment of the two people. So quite often we give advice to people who say, well, I'm being paid a really low rate because I'm seen to be a member of a couple with Centrelink, but I disagree. And sometimes they won't get a Centrelink payment whatsoever if Centrelink have decided that they are a member of couple with somebody, because the partner's payment might effectively rule them out from getting any social security. So we quite often run cases involving member of a couple determinations. So just going through the main types of payments that might come up that we'd be giving advice to people about. So payment is just generally used as a catch-all word for somebody who's getting social security. There's many different types of payments and they're called different types of things. So you might find someone has an application afoot for a pension. It's just a particular type of payment. For example, the disability support pension or the age pension, it has a particular type of rate attached to it, and it comes with benefits and associated supplements and a pension card that is different to some other types of payments. A person might have an allowance instead. For example, New Start allowance used to be the main one. Again, it's just a different type of rate of payment. Similarly, a benefit. So for example, special benefit, a particular type of payment that's paid to a person. They all mean the same thing. It's an amount of money the person has been found to be eligible to receive from Centrelink after putting an application or a claim form in. The age pension is paid for, sorry, I'm just going to bring up my notes there. So it's mean tested income support payment to older Australians. So the age is always changing. So I just wanted to check. The qualifying age is currently 66 years and 6 months. That will increase to 67 years of age in 2023. And the amount that somebody might be able to be paid, or whether they can be paid at all for the age pension, will change based on their income, their assets, and their working life residency. So how long they've been working in Australia. There's all kinds of things that come up for age pension in terms of the person living with the age pension overseas, returning to Australia, where they're residentially qualified. So it's best, get some advice about that. But those are the types of questions that might come up for age pension. Disability support pension is paid for people with a disability 16 years and older. And I'll go through the main words that come up for disability support pension in a separate section soon. That is overwhelmingly the payment for which we give the most advice about, and that is most frequently a decision before a Centrelink authorised review officer and before the Administrative Appeals Tribunal. And it generally is the payment type and social security issue type that we most commonly see vulnerable clients applying for who require assistance from an interpreter. So I'll spend a bit of time going through those words a bit later. So job seeker allowance is for people who are looking for work. There are often the words that will come up around somebody with a job seeker allowance issue will be around mutual obligation requirements or activities. So in order to get job seeker allowance, somebody has to sign up to a job plan with Workforce Australia or Workforce Australia online services, or potentially a disability employment service provider, which sets out a minimum number of activities the person's going to do over a specified period of time in order to continue to get job seeker allowance. So it comes with some requirements of activity, things like trying to increase skill sets to get jobs, or applying for a certain number of jobs, or doing some training or courses in order to continue to get the payment. AusStudy is a payment for full-time students and Australian apprentices aged 25 years and older. So people often see AusStudy come up for people that are doing study later in life, who are doing a bit of study and some part-time work on the side. Youth allowance is a separate payment for younger people aged 16 to 21 who are looking for full-time work, or it can also be paid for people who are 18 to 24 who are studying full-time. So if somebody's over 25, will be able to apply for AusStudy, but a full-time student under 25 would apply for youth allowance. Carer payment is for people providing constant care for a person with a physical, intellectual, or psychiatric disability who requires day-to-day support in their home. The care provider has to be giving support to the care recipient in their home. And again, it's subject to an asset and an income test. And special benefit is a bit of a tricky one, but it's a payment, it's a bit of a catch-all payment that's there for people who are not eligible for any other type of payment based on usually it's residency. And there's a certain exceptions that mean people could obtain special benefit if they're in financial hardship and some circumstances outside of their control has come up, but very contingent on the person's specific residency and particular circumstances around their financial hardship. So disability support pension definitely used to be 80 to 90% of our workload was in relation to disability support pension. It's slightly dropped because the criteria to get the disability support pension is so hard, and it's very tricky to meet the requirements of the payment. So we have seen less people at the tribunal in relation to DSP over the years, but still a very common topic that comes up for us in our advice sessions. So date of claim is critical for any disability support pension matter. It's the date that the person puts their claim form into Centrelink asking to be paid the disability support pension after Centrelink assesses whether they're eligible. And it's relevant, really relevant, because if a person puts a claim form in for disability support pension and Centrelink assess it and 6 weeks later say, no, we don't think you're qualified for the disability support pension on any number of bases, if the person then asks for a review of that decision not to pay them the disability support pension, which overwhelmingly happens, any review body, including a Centrelink internal review officer or the Administrative Appeals Tribunal, will not be reviewing whether the person qualifies at the time that they get up to them and have a hearing or a reassessment. They're looking back to see whether the person qualified at the date they put their claim form in. So quite often in advice appointments, we always talk about this date of claim, and it's really essential in that respect. So it will generally form the first part of any advice appointment. Disability is really the physical impairment or intellectual impairment or psychiatric impairment that the person has. That means they have a limited functionality or an impact on their day-to-day functionality. And for disability support pension purposes, it's really broad. There's no specific list of disabilities that a person has to meet to qualify or not. There are specific impairment tables. There are 15 different impairment tables for disability support pension under which a person might be able to get different impairment points. And again, it doesn't list particular diagnoses, it lists functional areas. So for example, table 2 is in relation to functions of the upper limb. So from shoulders down to hands. Table 3 is in relation to functions of lower limbs from the hips down to the feet. So disability is really broad, and it's important for everyone to get advice about being able to put a claim for disability support pension in if they do have a day-to-day functional impact. Permanency is the sort of the critical issue that comes up for disability support pension. So the payment can't be paid unless the person is able to prove, firstly, that their condition is permanent. And that means it's been diagnosed, it's been treated, and it's fully stabilized. So diagnosed means that an appropriate person has considered the condition in their medical expertise and has provided the person with a diagnosis. particular conditions require a diagnosis from a specified practitioner. So for example, for a mental health condition, a diagnosis has to come from a psychiatrist or a clinical psychologist in combination with a general practitioner in order for the person to be able to have their psychiatric condition counted for disability support pension. So when we give advice, we'll be talking about who can give a diagnosis. Generally, it's a general practitioner, but it would be expected that the person with specialty in a field that relates to the condition would be the person providing the diagnosis. Fully treated means that the person has undertaken all reasonable and cost-effective treatment that's been recommended for them that will lead to any kind of functional improvement for the condition. So by way of example, if a person's been diagnosed with a spinal issue and it's been suggested that some physiotherapy may assist them with their day-to-day function, if they put a claim form in for the disability support pension, it's likely that that condition would not be able to be counted if the physiotherapy had not yet been conducted and it hadn't been shown to not lead to any improvement for the condition. So a condition has to be fully treated before it'll be counted for disability support pension. And fully stabilized means that even after having undertaken treatment for the condition, that the condition is not going to get better. So it's reached a period of stability such that it's not fluctuating, that there's no evidence to suggest there's going to be a functional improvement. It has reached a maximum level of improvement. It's not to say that the condition is gone or that it's not going to fluctuate in the future, but it's reached with treatment, with medication, with specialist support, a maximum level of functional gain such that the Centrelink would be able to assess and say, yes, this person's going to have an ongoing issue in terms of this condition that's reached a stable level. Program of support is by far the trickiest issue that's come up in disability support pension in a long time. It is a requirement in order to get the disability support pension that you prove at the date of claim that you meet the program of support requirement. As in a nutshell, a program of support is a program provided by either a disability employment service or a Workforce Australia online or face-to-face service that is directed at things like job search, improving capacity to find employment, resume building skills, training, etc. To meet the program support requirement, generally a person needs to have done 18 months of attendance in a program support with a job plan without any exemptions in the 3-year period of time leading up to the date they put their claim form in. There's a couple of exceptions to that. The main one that comes up for our purposes that we often give a lot of advice about is if the person can get 20 impairment points for a single condition under a single impairment table. So for example, the person with the spinal function, if they end up doing the physiotherapy and then claim the disability support pension, that condition is found to be diagnosed, treated and stabilized, and they look at what impairment points could be given for spinal function. If they're given 20 points alone under the table for spinal function, which is table 4, they would automatically meet this program of support requirement as well, because one of the ways to meet it is if somebody gets 20 impairment points under 20 impairment points under a single impairment table. A person, just to close up on this, because we give so much advice about it, I think it's useful to cover what the concepts mean, but a person who gets a combination of impairment points for the disability support pension, I should have flagged, sorry, you need 20 impairment points in total to qualify for the payment. So for example, if a person got 10 points for their spinal function and 10 points for a knee condition, that would give them the 20 points they need in total to get the disability support pension. But once they assess program of support, because they haven't got 20 impairment points for one condition under a table alone, that person will need to meet the program of support requirement in another way, which may be through having done 18 months of attendance with a job provider or a disability employment service in that 3-year period before they claim the payment.
I might just jump in. That's a big one.
Yeah.
I might just jump in. You said the word table a few times. Can you just explain? It's not an actual table. It's a part of the Act, or how? What
Yeah,
the
sure. Yeah, of
tables are?
course. Yeah, sorry, I should have gone that through that more
No, we didn't
detail
have
at
that
start.
word, but that.
Yeah. So with Social Security, with Disability Support Pension, generally it's the Social Security Act that sets out when somebody will qualify. And as part of Section 94 of the Social Security Act, it goes through that the person has to have a disability and fully diagnosed, treated and stabilised conditions, and obtain at least 20 impairment points under the Social Security impairment tables. Those tables are set out in a separate document called a determination. It's still law, it just is more easily able to be changed than the Social Security Act itself. So it is a piece of law. There are 15 separate tables that exist in that document, as well as some rules for how people should apply those tables. Each table has a description of what's required to get 0 points, 5 points, 10 points, 20 points, and 30 points for the 15 different types of functional impacts. Just very generally, there's a table for stamina and physical exertion, upper limb function, lower limb function, spinal function, mental health function, intellectual function, hearing loss, vision loss, digestive function, functions of consciousness, for example, headaches or migraines and things like that. So there's 15 different tables, and each one deals with a different function. And within every single one of those tables is a list of different examples of when a person might meet 0 points, 5 points, 10 points, 20 points, and 30 points. And for disability support pension, the person needs to show in evidence for their permanent conditions that they get at least 20 points across those tables. And the real catch-all comes to the program support to see, okay, did they get that combination of points? Do they now meet the program of support? Continuing inability to work. So somebody also has to meet the continuing inability to work requirement in order to obtain the disability support pension. And that is that they have to be able to show when they've put their disability support pension claim in that they're unable to work 15 hours per week, and that would be the case for at least the next 2 years. And it's not just in the job that the person was last doing, it's any type of work in the open job market, and it doesn't take into account the person's prior expertise. It really looks at if the person was given training and assistance to do a different type of job in a different field, could they do 15 hours per week over the next 2 years? And improving capacity to work is a concept that's kind of brought up in disability support pension all the time. The continuing inability to work component discusses the person's capacity to work and improve their capacity to work. The program support talks a lot about whether or not the person can do a program that will improve their capacity to work. There's another exemption to the program of support, which rarely, if ever, comes up, but it basically says if a person is doing a program of support at the date they put their disability claim form in, and it can be proven that the program itself will not help the person to improve their capacity to work or their ability to plan for, prepare, or obtain work, then they can potentially argue they don't have to keep doing it. So it's really about what the person can and can't do due to their disability. So issues preventing payment, there's many. So an income maintenance period is the length of time a person may need to wait before they can get a Social Security payment because they've been given a number of payments that relate to leave periods or redundancy, etc. So a person who's made redundant from their position, if they're given a 10-week redundancy, they'll have an income maintenance period of 10 weeks. And it's to ensure a person doesn't get a Social Security payment at the same time that they've also got a leave payment reflecting that period of time. A liquid asset test waiting period. So there's a waiting period that certain payments have as part of their eligibility criteria or assessment criteria, such as job seeker. And this is somebody's liquid assets is things like availability to get money quickly. So it's usually cash in the bank or money that the person has. It's a calculation that Centrelink does of between 1 and 13 weeks, depending on the level of the person's assets. If a person had $23,000 available to them in a bank account when they claimed job seeker allowance, they would have the maximum liquid asset test waiting period that can be applied, which is 13 weeks. If they had $11,000 in their bank account, they'd have the smallest amount of liquid asset test waiting period that can apply, which is 1 week. So anything $10,000 and under, there will be no liquid asset test waiting period. So compensation, we often advise about somebody's ability to get a payment related to compensation. So compensation is a payment made to the person wholly or partly in respect of lost earnings or lost capacity to work because of some sort of personal injury. It can be a periodic compensation payment, or often, as we see, a lump sum award of compensation for an injury a person's experienced and the impact on their ability to work in the future. Where this comes up for us in the Centrelink space in terms of giving advice is that often people will come to us seeking advice about a compensation preclusion period. So that is a period of time that the person who's received compensation is unable to receive a social security payment because their lump sum compensation is going to be treated as covering a period of time that they can't work. And so you can't get social security for that same period of time. It's a very complicated formula, but in a nutshell, they take the lump sum compensation, do a division and work out how many weeks the person is expected to live off that compensation. That number of weeks will be what the preclusion period is. An income cutoff amount is a part of the test that's used to work out the preclusion period. For example, they might take, if it's a lump sum settlement of compensation, the person's awarded $500,000. The calculator provides that 50% will be seen for lost ability to work, 50% will be seen for pain and suffering and other things. The 50% that's for lost ability to work will impact what the compensation preclusion period is. The income cutoff amount is the point at which a person earns too much income to be eligible for any specific social security payment. So Centrelink will apply that income cutoff amount to the $250,000 that's seen to be for inability to work out how many weeks the person would live off that money. So it's a favorable, in some ways, calculation based on maximum social security somebody, the maximum amount of money somebody could earn and still get a social security payment. So they have to come up with some figure in order to work out the weeks of the preclusion period. The asset test limit, so this isn't really involved in compensation too much, but basically similarly to income cutoff amount, there's a asset test, different limits and tests across different payments. So for a social security payment, when the income test and the asset test are applied, there's a certain point at which a person will have too many assets to be able to be paid a part payment anymore. And similarly with income, when you're talking about income cutoff amount for general eligibility for a payment, there'll be a certain point at which a person will earn too much money to be able to be paid, for example, age pension or a disability support pension or job seeker. It's different for each payment too, so the person will get specific advice about it. So reviews and appeals. Generally, a person who is going to seek a review of a decision, and Centrelink is a rights-based system. So you've got a right to seek a review of a decision that is adverse to you or that does not meet your needs. So generally a person would get a refusal letter if they have claimed a payment that they're not entitled to, or Centrelink say they're not entitled to. They'll get that in writing setting out why they're not eligible. Review means a review in the first instance by a Centrelink internal review officer known as an authorised review officer. Time limit, as with employment law, there are time limits that apply to each stage of review. So if someone gets a Centrelink decision that they'd like to get a review on, they have to seek a review within 13 weeks to an authorised review officer in order to get potentially back payment if they're successful on review. There's no time limits though for some issues. For example, if someone has a debt, there's no time limit to seek a review of the debt matter. An appeal is similarly used in discussion of getting a review. So a review or appeal, those words are interchangeable in that sense, but appeal generally is used more often or not at the Administrative Appeals Tribunal. So someone has an appeal before the Administrative Appeals Tribunal, or they want to appeal the decision. But review and appeal can be used interchangeably in that sense. Debt. So debt can be an amount of money that Centrelink believe the person has to pay back because they've been overpaid a social security payment. It could be that new information has come to light about the person's employment or their partner's earnings and they were paid too much, or the person didn't update all of their income, or it could be a debt because Centrelink believed the person was in a relationship and they weren't entitled to a certain payment. So debts can come up at any point in time, and a person can seek a review of a debt. Waiver in this area of law is about whether or not a debt can be waived, and it means not have to be paid. So as distinct from, this is confusing, but in the social security space, to get a write-off of a debt means that you still have to pay the debt, but don't have to pay it for a specified period of time. Whereas a waiver means that you do not have to pay the debt. The amount that is decided to be waived no longer has to be paid by the person. In the space of debt waiver, are some different terms that come up, which are special circumstances, administrative error, and financial hardship. So under the Social Security Act and also in related financial assistance legislation, which relates to family tax benefit, there are waiver provisions that say a debt can be waived if the person can show they have special circumstances and financial hardship, or if the person can show that the debt is because of administrative error, sole administrative error, and the person has financial hardship. So special circumstances are not defined in the legislation, but they're defined in case law as circumstances that are uncommon, out of the ordinary, or above and beyond circumstances. Sole administrative error means the debt is wholly the result of the Commonwealth government making an error that's led to the debt. By way of example, if a person called up and said, I currently earn $100 per week, and Centrelink said, yes, I've recorded you earn $100 per week, but they recorded $1 per week instead of $100 per week. If the person's not notified in any way of the assessment of their income by way of a letter, for example, if it comes to pass the person has a debt down the track, they could argue that debt may be sole administrative error and should be waived on that basis. Both of those waiver provisions involve an assessment of financial hardship, and that means proving the person is in financial difficulty, and it's difficult for them to be able to afford basic necessities such as food, accommodation, clothing, etc. So it's quite a strict test. A freedom of information, often with someone seeking a review or wanting to challenge a decision, it's useful to get information about what's happened in the past for them. And so anybody at no cost can do a freedom of information request of Centrelink to get documentation that relates to a past period of contact with Centrelink, and they can get advice from us about how to do that and what's involved. An administrative appeals tribunal is the main body that ultimately all Centrelink reviews will get up to. So once it's been reviewed internally by an authorised review officer, a person has a time limit of 28 days to then appeal to the, once it's been through an authorised review officer, the person has 13 weeks to get to the Social Services Child Support Division of the Administrative Appeals Tribunal. So in Centrelink law, there's two different appeal mechanisms. Then they've got 28 days to get to the General Division of the Administrative Appeals Tribunal. So just quickly on the National Disability Insurance Agency and the National Disability Insurance Scheme, because we often also we do give a lot of advice in this area. So the National Disability Insurance Scheme is the scheme that provides supports to people with a disability, their family and carers. So a person would apply to get access to the scheme. And then once they get access to the scheme, they would be given an NDIS plan that includes specific individual supports the person has requested and that have been deemed to be reasonable for them. The National Disability Insurance Agency is the Commonwealth Government organisation that administers that scheme. So access, so the catchword in terms of NDIS and trying to get, some sort of money and support from them is a person has to put in an access application. and the National Disability Insurance Agency will assess whether or not a person meets the access eligibility criteria to be able to obtain support through the NDIS. There's general access criteria that looks at the permanency of the person's condition, their substantially reduced functional capacity to do certain activities such as mobility, self-care, self-management, communication, social interaction. And there's early intervention criteria, which looks at whether or not if the person gets supports early on, is it likely to mean that down the track they won't need as much support? So there's two different avenues that a person can get access to the NDIS. And yes, so permanency and substantially reduced functional capacity are the main tests that come up in the access criteria, along with proving that the person has a lifelong need for NDIS support. So for example, that the person is going to need some sort of support from a personal care worker or some sort of specialist assistive technology for the rest of their life. So once a person gets access to the NDIS, they're going to be called a participant of the National Disability Insurance Scheme. So you become a participant. And once you're a participant, you'll meet with a planner, and the planner will work with you to develop an NDIS plan. The NDIS plan is a document that contains details about the person, their supports, and then it includes all the funded supports that the person is given. The statement of participant supports is the part of the NDIS plan that sets out the particular details of the person and what's being granted to them. Reasonable and necessary supports is where we generally give advice to people. So in order for an NDIS plan to have a particular support included in it, for example, 10 hours of a support worker per week to come to the person's home, it has to be shown that that particular support meets the reasonable and necessary support criteria in the NDIS Act. The main things in that reason, and all of the criteria in the section on what makes a reasonable and necessary support have to be met for every single support in the NDIS plan or sought to be in the NDIS plan. The main ones that come up are value for money, which means trying to show that the cost of the support is value, particularly in comparison to alternative supports that might or might not exist, and the benefits that the person will obtain from the support. Effective beneficial is an assessment of whether or not the support is proven to be effective. Is there research and documentation that shows it's generally beneficial for people? Are there specific therapists or specialists showing that what the person is seeking is going to achieve their goals and long-term be of particular benefit to them? Lifelong support under the NDIS. So sorry, that was on the wrong page. We've covered that in the previous page. And review request is very similar to Centrelink matters. If a person is not granted access to the NDIS, or the person has an NDIS plan that doesn't include all the supports that they're seeking, they can seek a review. A review in the NDIS area needs to be made to an internal reviewer of the National Disability Insurance Agency within 3 months. Okay.
We have had some questions come in, Rochelle, that I'll ask to you. The first one we got, which might be a little bit specific, but if there is a general answer, let us know. Fiona said, we hear frequently of terminal cancer patients who are denied disability support pension. Do you know the reasoning behind this? Does it go down with the fully stabilised or permanent conditions that are mentioned?
Yeah, I mean, often that terminology of fully treated and stabilised can often be a bit of a prohibitive requirement when it comes to terminal conditions and where it may be difficult to get evidence or where someone's undergoing particular treatment, and the nuance of trying to show, well, this treatment is not to improve the condition. The treatment is obviously to prevent deterioration and improve the person's functionality as much as possible for as long as possible. So in my experience, it doesn't come down to the particular tables necessarily. It comes down to whether the condition is treated. And I know that sometimes the issue can come up as well about where does a person get impairment points? And if they haven't got 20 impairment points under a single impairment table, which a person who has a a terminal condition might have a functional difficulty across many different tables. The issue might be whether they can meet that program of support requirement when they are so unwell. And if they're not able to, often the people we find who are most vulnerable and most unable to participate in a program of support, who've got significant vulnerabilities, are going to be the people that can't meet that requirement, because it's very tricky to do 18 months when you're that unwell. So it could be either of those areas, but of course, book in for advice and we can give some specific detailed advice to the person.
Awesome. The next question is closer to that program supports question. Someone's asked that after 18 months on the program and support, the last 3 years, if the applicant passes the 20 mixed points but still does not pass the 20 points in one table, does the applicant then become entitled to the DSP?
Yeah, so if a person has done 18 months of a program of support in the 3-year period leading up to when they put their claim form in, all they would then have to show is that they've got permanent conditions that give them a combination of 20 points under the tables, and that they can't work 15 hours per week for at least the next 2 years.
Yeah. So they can be spread out, those 20 points. And
yeah, you could have
that program's done.
Yeah, exactly. So if you've got the program support requirement, you could have 5 points for upper limb function, 5 points for lower limb function, 10 points for spinal function, as long as you've got the full 20 points across the tables, if you've done the program support.
Yep. They're all the questions that I can see. Has anyone else got any other questions they'd like to ask now before we go? We both mentioned booking in. You both mentioned booking in for advice. So I'll just talk briefly to that now. We have one direct number that everyone can call for advice through legal aid, which is the Law Access number. And then Law Access does an assessment of your location, your need, and will book you into the relevant clinic or give you advice if they can on the spot. Legal aid has lots of locations all over New South Wales, and I'm sure there's people joining us from all over the state. So please call that number and you'll be directed to the appropriate clinic and location from there. No more questions are coming through unless anyone had any other. Alex, did you have something else you wanted to add?
No, I think we've covered it. Please, yeah, if anyone you know or people you speak to, and if you're doing interpreting and maybe some of these issues you hear arise and they're not, maybe you might suggest to them that they might want to get advice if it pops up.
Yeah, this session is about us helping you to learn legal words, but we always require the help of people in the community to send clients to legal aid, help to issue spot, and stay informed about what we're doing and how we can all help each other. For sure. Oh, one new message has come through. Yes, the certificates. If you require a certificate for this session, we do have certificates available, and you can email the email that's come through for your webinar. We can email a certificate to you. How does NDIS regulate unreasonable changes put in by the support providers? Or do you want to, if you got an answer for that one, Rochelle? I don't know. How does NDIS regulate the unreasonable charges that are put in by the support providers? That sounds like a consumer law issue.
Yeah. So I mean, I should have also flagged as well that in NDIS, I was speaking to terms that come up for getting access to the NDIS and also in relation to NDIS plans, but there's a whole other section of the Civil Law Division that gives advice about the consumer issues in relation to the National Disability Insurance Agency. So contracts that participants might have with providers and any unreasonable terms that might come up. So again, I think it's one to book in for advice because that'd be quite particular to the person's circumstances and if they're plan managing or if it's agency managed, etc.
Yeah, awesome. Okay, well, I might end it there. So I'll put the email address in the chat, but Rochelle and Alex, you can log off and I'll filter any more questions that come through. Thank you so much for joining me
Thanks,
today.
everyone.
Thanks, guys.
Thank you, everyone, for attending.
Bye.
Bye, all. I'm going to put the email address in here because I know that some people will want the certificate. Thank you. I'll put that email in the chat. If you want to copy that email address and send us an email, we'll send back to you a certificate for attending this training. Thank you, everyone. Thank you for sending thank yous. Thank you. I hope you have a lovely rest of the afternoon.